Hello, I'm Stephanie Quine with the Weekly Law Report. In this week's video, we look in depth at lawyers working flexibly and diversity in the profession. A new law to improve equal pay and opportunities for women is set to put pressure on law firms to address gender inequality issues. The Workplace Gender Equality Act aims to get rid of discrimination on the basis of family and care responsibilities. From 2014, firms with 100 or more employees will have to report on gender equality outcomes and provide standardised data for their staff, shareholders and clients. Partner and Head of Diversity at Norton Rose, Sally MacIndoe, described it as a terrific step forward, but said there's still a way to go.
There's still a lot of work to do. I think that it's a slow process in professional services firms. That's partly the way they're structured. I think we're really starting to see an understanding and acceptance of why it's so important. I think we're starting to see results, but it's slow progress.
The Law Society of New South Wales is also urging firms to get flexible. Last week, it launched a new resource aimed at helping lawyers implement flexible work arrangements. President of the Law Society, Justin Dowd, said solicitors and firms need practical tools to turn good intentions into effective reality.
There are ways that firms can help a practitioner form a pattern of working that works for everybody. So it has to work for employer, employee, and of course the clients, who are very much part of this process. In 2011, the Law Society produced a report called the Advancement of Women in the Profession report, and that report contained a number of recommendations. One of those recommendations was to follow up the question of flexible work practices, to draw together the information that we had from the experience of interviewing a lot of practitioners. And we've done that, and very recently issued a flexible working report. That report talks about steps that can be taken to assist firms and their solicitors achieve more flexible work practices. So technology is obviously helping in that, being able to work from home, having a system that is sympathetic to people working from home, for example. Job sharing is clearly one. Flexible work hours to fit in either around children or partners' employment sometimes. All of those are things which are comparatively obvious, but putting them into practice is something that not a lot of firms have done. And this report contains practical suggestions about how that can be done.
A survey released on Monday by the Victorian Equal Opportunity and Human Rights Commission found that hundreds of female lawyers have been sexually harassed, bullied or discriminated against, but most admit they never speak out about it. The survey confirmed that a major barrier to women's advancement is the limited availability of flexible work arrangements. While 79% of women lawyers had their request for flexible hours approved, they reported employer attitudes then ranged from outright hostility to lack of support and pressure to increase work hours.
The attitude of the employer is very important. At one level there can be an approval or an acquiescence to a flexible working arrangement without real support. And support includes emotional support, and it includes practical support on a daily level. It certainly includes support in terms of the work that the solicitor is allocated and is able to follow through with. So it has to be, a flexible work practice has to be something that everybody is committed to. And really, it's only going to work when both men and women work together, and when men want to adopt similar styles of practices, because until then there will be resentments between the people who are working flexibly and those who are working according to a traditional model.
While the New South Wales Law Society doesn't have an official position on diversity quotas, Victoria's Equal Opportunity Watchdog recommended the profession consider developing sector-wide targets for quotas for women in leadership positions. Sally MacIndoe, who helped Norton Rose to double the number of women working flexibly and at partnership level, said that targets can genuinely encourage diversity.
I think targets are really important. I think in law firms in particular, to try and set quotas is a bit hard if you're talking about them at a partnership level, for example, because of the way we're structured. But I think targets are really, really compelling. We want to make sure that we're always appointing on merit. Targets can be token or they can be real, and if you really work towards targets and you really bring that throughout your organisation, embedding it and make it meaningful, and that they have to be delivered, they can be incredibly effective. And at Norton Rose, the setting of targets each year in every area of the business and having that reported right up to board level has been an incredibly effective way forward.
That's all we have time for in this edition of the Weekly Law Report. I hope you enjoyed this week's focus on diversity and flexible work arrangements. Don't forget you can follow us through the week on Twitter, like us on Facebook and join in discussions on LinkedIn. I'm Stephanie Quine. Thanks for watching.